Hello. Um, I would like to discuss with you the legal issues pertaining to e-books, and I mean the central question is whether we should deal with e-books in the same way as we deal with books. So the previous speaker said that this is the case, but maybe this is not quite right. So when we discuss the copyright issues regarding ebooks, there are three are the most important issues which should be dealt with: the legal definition of an ebook, the marketing, and the regulation of uses of ebooks. So there are different ways to produce ebooks. One way is to digitize an existing book, and another way is to create an ebook from scratch. I mean, to make a digital prototype. So we've started with the digitization of books. So ebooks can be both electronic books created and distributed in digital form, but also it can be paper books which have been digitized and are being distributed electronically. So the copyright issues here are related to the question of digitization, which are related to the question of digitization only emerge in the case of books which are in paper format and then are being digitized and potentially enriched with additional features. Professor Politis already introduced us into this concept of rich content, of adding additional media to books. So this is what we should make a research here. So it is well established that when we convert a printed book to an e-book through scanning, this is an act of reproduction. So it actually requires the consent of the author or other right holder. So what happens with existing contracts? Let's say we have already a copyright contract with a publishing company for a printed book. Can this publishing company also be engaged in the digital production of e-books without asking the author? This is not the case. This is not the case because it is to scan an existing printed book or to reproduce it and make it an e-book is a new art of reproduction. This has been there is a case law on this issue. It's a famous decision, the Authors Guild versus HathiTrust. So where the court deals with the scanning of books which are being used in the context of the Google Books project. I suppose you are all familiar with the Google Book project. And this HathiTrust, this is a company which uses the same technique in order to provide books online, but particularly for people with print disabilities. So in this case, the court did not find a copyright violation. It ruled in favor of the Hathitrust company in view of the fact that there is a fair use exception, as it is being called in legal terms, which means that this company has the right to offer services to people with handicaps, to people with disabilities. But the most crucial in this decision is that a digitized book cannot be seen as a simple extension of the book in paper format. So it becomes clear that if there is a contract before the widespread use of digital of e-books, and this was unknown to us. We didn't have any perception of what the future would bring. The publisher does not have the right to digitize a work without the author's specific consent. And there is another famous decision which is called Rosetta. So I will go very briefly. So in this case, we have a publishing house called Random House and a startup company which publishes e-books on the internet, and it actually published books from authors which were already printed, which already were already distributed in print form. So the publishing house claimed that this is a violation of copyright because they had the right to print format. But the court rejected such the arguments of the publishing company, and it actually said that the authors granted that because the authors granted it the exclusive right to publish their various works in book form, that doesn't mean actually that they have the right to publish the books in any form. So this is a new way, an e-book is a new way of exploiting the work. This is a new commercial product. It is similar to software. Yeah? You may all agree with me that it's not a typical book. It is not a typical book, and it resembles software or multimedia. So that is how we should see it legally and classify it as a new way of exploiting the work for which we need to make specific copyright contracts. And it is actually e-books are complex works with additional features, with rich content. They may have a video or whatever. So this is something which makes them different, substantially different from any other printed book. Of course, there are some limitations when we make an e-book and when we digitize e-book because of the moral rights of authors. And there are other legal issues concerning the marketing and licensing of e-books. So when we make a contract today, we should specifically define the electronic rights and the scope with which they are granted. So the copyright contracts should be adapted to this new reality. And there should be specific terms to cover the right of making available, because in e-books we don't sell physical copies, we rather sell a right to access an e-book. So what is here important is to make available the e-books over platforms, over websites, and this is this is covered by this right, by the right of making available, which is of course different from the right of reproduction that mainly addresses the use of printed books. We have, of course...
You have to move to conclusions.
I'm finishing. Problems with public lending. Normally, when you go to the library and you can lend a book. But what happens with e-books? Can you also lend an e-book from the library? This is very problematic, actually. And we have problems with private copy and other technological exceptions. Sometimes DRMs are being used, and so on. So by finishing, I would like to mention that books have always been a significant vehicle for the preservation and dissemination of culture. And new technologies have significantly influenced the ways in which books are created, produced, published, perceived, and used. So the transition from books to e-books not only sheds new light on how books form part of human history or on our reading habits, but also calls for a legal definition of this new product of technology and determination of the new legal regime that governs the use of e-books. Thank you very much for your attention.
Thank you.